This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are joined now by Todd Lutsky from the law firm of Cushing & Dolan for Ask Todd. If you have a question that you want to ask Todd about your estate plan, this is your chance right here. Right here on the air, you can ask Todd Lutsky your estate planning question. How do you call the studio? 888-205-2263. That is the studio number here for you to ask Todd Lutsky your estate planning question. That number again is 888-205-2263. So get calling to make sure that you have a space so that you can, ask Todd your estate planning question. Mr. Lutsky, how are you today?
I am never better, thanks.
I'm in a little bit of a weird place right now, Todd.
Yeah, what's wrong?
Went to the zoo yesterday.
Yeah, what'd you see?
Saw a baguette in a cage.
Oh, baguette.
Zookeeper said it was bred in captivity.
That's good.
So you're seeing all kinds of weird stuff out there today. Todd, let's talk a little bit about owning real estate. Let's take kind of your basic situation. Now, most people typically own real estate in their name, whether it's owned by a single individual or owned jointly. Pros and cons of simply owning real estate in that fashion.
So if you own it in your own, so we're talking about spouses here, spousal situation?
Yeah, let's use a spousal situation.
So start with that, because that's the most common, quite frankly, folks. If you're married and you've got assets, real estate assets specifically, because these are tricky. How do you own it? Generally, you're going to own it jointly. You're going to have both your spouse's names on the deed. What does that do for you, pros and cons? Well, one, when you die, if one of you die, it automatically passes to the surviving joint owner. I assume joint with right of survivorship. That means that it would avoid the probate process. So it would go right to the surviving spouse, the surviving joint owner. And that's about it, folks. And let me tell you why I'm saying this, because it doesn't do anything else, right? Think about what you didn't get by owning it that way.
What else could someone have?
They could have had a trust in place instead for joint ownership.
And what would that do?
But before that sort of leads into why jointly owned property does nothing other than avoid probate. It does not help you reduce your estate tax liability, because it went right to the surviving joint owner. It does not protect assets from the cost of long-term care. Just went right to the joint owner, if these are your wishes. And it really doesn't help you provide a nice bloodline distribution to your family, whether that involves, generation skipping tax planning or protecting it from kids' future divorces. It doesn't do any of that. So when I say jointly owned property between spouses, while it's very common, I don't think it does much. In fact, I'm not elated with that idea.
So let's say someone says, "Okay, great. You know what, Todd? My property, I don't own it jointly. It's in a nominee realty trust." What does that do?
Yeah, that's could be another disaster, because nominee realty trusts are complicated. They're not really trusts, as we've mentioned in the past. They are really just basically an employer-employee relationship. What I mean by that is, once you put it in there, the beneficiaries of that nominee realty trust become the owners. So now what you find is oftentimes that'll be set up where mom and dad put it in. Beneficiaries are mom and dad. Okay, have we done anything? No. We're not even avoiding probate. We put it right back into their names alone because it flows through. So not helpful, again, from a planning standpoint. And if you are unfortunate enough to think that these beneficiaries are not the owners while you're living, and most people don't think that when they set these up, you put the kids there as beneficiaries. Now you've given them the property right away, right now. They don't even know it yet, but I can tell you, if they get divorced while you're living, folks, they're going to know that they're the owners. So you don't want to find that out the hard way. So nominee realty trusts are tricky and probably not my favorite way to own real estate.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you have a question for Todd about your estate plan, this is your chance to ask him right now on the air. The studio line here is 888-205-2263. Again, that number is 888-205-2263. We're going to take a quick break right now, but when we come back, we're going right to your questions with Todd Lutsky. So again, that number is 888-205-2263. Your calls right after this.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
All right, as promised, we're going to go right to your questions with Todd Lutsky. Let's kick things off with Barbara in Boston. You are on with Todd Lutsky.
Yes, hello. I'd like to know the things that you're supposed to have in your estate, such as a will, and there are other things, trust, will, and power of attorney. Could you please name me the specifics? Yeah.
Sure. So I think what Barbara is asking folks is not just for her, but for everybody listening. I mean, basically, when you're doing an estate plan, what does an estate plan consist of? What do you get when you do an estate plan? And of course, I have to tell you that it tends to vary depending on the size of your estate. But let's just say the foundation, the basic estate planning, in which pretty much anybody needs to start with. And then whether you build on that is a different story. But let's say you're under $10 million and you're doing basic estate planning. Say you're in that world getting your estate planning done. At a bare minimum, I would think you're going to need wills, and the wills will likely work with the trust. They're called pour-over wills. You would likely need healthcare proxies for medical decision-making. Usually it's each other if you're married, and then another person, anybody you want, a child or whoever you feel comfortable making medical decisions. Usually you get a HIPAA form. That's that document that allows other people to get your medical records. Even if you're still competent but just unable to get to the doctor, you can have someone else get your medical records. And generally a durable power of attorney, which also would work with the trust. It'll reference the trust. And that document is you granting somebody else the power to access accounts, bank accounts, fiduciary, brokerage type accounts, that all accounts that are not owned inside a trust. Okay, so that allows other people to pay your bills if you cannot, etc. And lastly, you're going to need some kind of a trust. And this part is going to depend primarily on the size of your estate and the goals that you want to accomplish. So if it's simply avoiding probate, reducing taxes, providing a bloodline plan to your family, probably a revocable trust will be fine. If you're married and you're larger than, say, $10 million, you'll probably want two revocable trusts, one for each spouse. If you're single, simply one trust. If you wanted to add creditor protection or nursing home protection into your mix, then you're likely going to need an irrevocable trust. So those are the basic documents that I think you need for what I call estate planning 101. And folks, interestingly enough, it is a new month. It's a new guide. And when we talk about these things that Barbara just wanted to learn about, right? You need to figure out how to fund your trust, right? That trust needs to have assets in it if you're going to do it. And most people have real estate in their world, and we need to know how to own our real estate. So I've got a new guide, which is real estate, how to own it, and how it's protected, right, for this month. And this new guide offers you the ability to understand jointly owned property, rental property. What about LLCs? How do they fit in? Do you ever want to give away your property? What if you add your child's name to your home or your rental property? Are those good things? Think about the control and tax issues that go with them. Folks, the new guide, you can get it 866-848-5699 or legalexchangeshow.com. Folks, everybody has real estate, and you need to know how it fits into your estate plan, how to own it. 866-848-5699 or legalexchangeshow.com.
Todd, we've got another question for you. Let's go to Jim in Haverhill.
How you doing? Can you guys hear me?
Yes.
Yes. Hi, Todd. Real quick question. I have a two-family with a mortgage on it. The property is probably in about the $800,000 range. The mortgage outstanding of balance is about $350. So leaves me appreciation about $450,000. I have a 401k, probably a little north of $200,000. Hopefully that will grow. I'm 63. I'll be turning 64 in November. My wife will be turning 60 in November. And we have a couple of whole life policies that we could cash out at any time. But
What's the face value on those?
I want to say they're like, I think they're $25,000 policies, which matured. But I think if I would cash them in right now, they're like $15,000 each, so about 30.
So let's just go 25 each. That's fine. Go ahead.
Okay.
Anything else?
And then I'm just basically, that's pretty much it. It is a two-family, so I do have rental potential at some point. Right now, I'm not really doing that because I have family that lives with me in the other, in one, I guess, section of the house, the first floor.
Yep. So the question is, what should you do if that's, now that I have this background, what kind of planning makes sense? 63, 60, that's a great age to be thinking about planning for sure. And the issue here is you can't really do much with the 401k. That's going to have to remain in your name because, you can't transfer it without paying a huge tax or penalties or whatnot. So you leave that where it is. Sounds like you probably have a small savings checking account that you didn't mention that just collects maybe ultimately Social Security or pension and things like that. Certainly leave that alone. Your biggest asset is your two-family. Not surprising, folks. This is what is generally the biggest asset for a lot of people. And so in that regard, we need to figure out how to own this real estate. Well, seems to me that if protecting that asset from the cost of long-term care is important, I'm going to suggest an irrevocable trust for that. If it's not, a revocable trust. Now, even though it's a rental property, I'm not going to tell you to put it into an LLC as much as I like properties that are rented in an LLC to provide creditor protection. I can't do that for this one because you live in half. And if you live in half and we put it in an LLC, then you're going to lose your capital gains exclusion associated with the sale of that property. So we wouldn't want to throw that into an LLC. At least this way, if you ultimately sell it later, even if it's in an irrevocable trust and you sell it later, at least 50% of the gain would still be available for that $500,000 capital gains exclusion that a married couple gets, or for other folks, $250,000 if you were single. So I'm thinking that should probably be owned in an IRREV trust. And if you're going to put it in an IRREV trust, I know we talked about life estates last time. This would be one of the times I might suggest keeping a life estate for yourself, because with a two-family home, putting it into an irrevocable trust, if you retain a life estate, you're entitled to collect that income directly, right? Not only does it give you technically the right to live there, but it also gives you that right to have the rent just come to you directly. It doesn't flow through the trust. I don't need to open up a bank account in the name of the trust to collect that rent. It can come directly to the life tenant. You put it right on your income tax return, and it's such an easy way of operating your rental property. So that's how I would do it, and I hope that was helpful.
Todd Lutsky, thank you so much for joining us today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. Evaluating how to smoothly pass along assets to your family is a huge part of a solid estate plan. Your home is most likely your primary asset, and if you think simply transferring it to your kids is the easiest way to go, you'd be taking a major risk, especially if they divorce in the future. Don't put yourself in an awkward position of having to buy back your own home just to protect it from creditors. Get Cushing & Dolan's brand new guide called Real Estate, Who Owns It and How It's Protected by calling 866-848-5699. There are better ways to own your real estate, and this guide will walk you through the process step by step, answer any questions you have, and put you in a more advantageous position to avoid probate down the road. Don't put your home at risk. Call today at 866-848-5699 and ask for your free guide, Real Estate, Who Owns It and How It's Protected. That's 866-848-5699, or you can request the guide online right now at LegalExchangeShow.com.